What are the pros and cons of a trust? So let me get back to what is an I love you will, and why is that a simple outright will attractive to people? It's because of its simplicity, because it's understandable. It says everything goes to my spouse, done. I don't have to think about it anymore. So that's the pros of an I love you simple will. I've told you about a lot of cons, that there's no asset protection and all those problems, right? But take that back to the question here about pros and cons of a trust. What's the pros of a trust? The pros of a trust are you sign it and you believe you're done, and it avoids probate. Done. You don't even really need to understand it. It seems simple and it's off your plate and you don't have to worry about it anymore. Well, that leads me to the cons of a trust. With a trust, it's even harder to understand than a will, even a will with asset protection contingencies, because it's like a legal fiction. What is a trust? I mean, if it's a trust, it's an entity that you have created by signing a document, by saying you're the grantor, the trustor, and you're in charge of it. So you're the trustee and it benefits you. So you're the beneficiary. And usually trusts are much longer than wills. There's tons of language in it. So it's a little confusing for sure. And then you got to keep in mind that a trust needs care and nurturing. It's not a one and done proposition. Maybe when you started this trust, you had a lawyer that helped you and they put your house into the name of the trust. You did a quitclaim deed to the trust, but then you sold your house and then you bought a new house, and then you didn't think about it should be in the trust, or somehow got away from you, or maybe you did put the new house in the trust, but then you didn't realize that your bank accounts or your investment account should be in the name of the trust, and you opened up a new account and you didn't put it in there. And then maybe you didn't understand that not all assets are actually titled in the name of the trust, like your life insurance policy likely isn't in the name of your trust. And are you going to say on the beneficiary designation that says when you die where it goes, outright to my spouse? Or are you going to say it pays to the trust? Lots of people say it pays to the spouse. What if the spouse doesn't survive, or they survived just for long enough that it went to them but not to the trust? Now you got to do a probate of the spouse's estate, even though you had a joint trust. Another real big concern with trusts beyond what I've talked about is your IRA or your 401k, your retirement funds. Those are for many people, a very large part of what their estate is. And that's not governed by your trust at all. So you need to make sure that you've got a beneficiary designation. And typically that beneficiary designation will be to a person and not to the trust. So when you have a revocable living trust, it becomes more complicated. Do not do a revocable living trust on your own. And if you do have a revocable living trust, make sure you understand it, and feel free to go back to the lawyer who drafted it for you and have them explain it to you and how it works. Lots of attorneys do revocable living trusts, and they'll have maintenance fees for you because it requires, an annual review oftentimes. And so they'll charge you every year to help you manage it. Well, those are a lot of the cons of a trust. One thing I'll say about one of these pros of a trust, supposed pros of the trust, is that it avoids probate. What we find oftentimes with revocable living trusts is because they don't require a lawyer to do the probate. What happens is when somebody dies, the trust might have said, okay, now it separates into an irrevocable trust for this portion of what was in the trust and a survivor's trust for this part. And it says work has to be done, but the surviving spouse, why? They don't remember that. They're not reading it. They're not going back to the lawyer. They don't know that what they were supposed to do was set up different trusts when the spouse dies, and there was no lawyer there to guide them, and they don't want to go back to the lawyer because they don't want to pay any more in legal fees. Especially, that would be especially harmful if this was a taxable estate and the couple needed to capture the deceased spouse's credit shelter exclusion amount, 2.193 million in Washington. If they didn't do that, as a result of being shy, not going back to the lawyer, not understanding it, not having to pay some costs for legal fees, they might end up, paying taxes, estate taxes, to the tune of tens, if not hundreds of thousands of dollars. That's the problem with a revocable living trust, is that you don't seek out legal guidance when you should.